Very good evening, Sammy. Good evening, students. Please confirm about the voice and the video, Sammy. Yes, any volunteer, please confirm about the voice and the video. Okay. Very good evening, everyone. Namaste, Ladli. Okay, on that note, let's begin with this class. So, first of all, I welcome each one of you to my class on the MCQ test of contract, SRA, and SOGA. So, basically, today we are going to, solve some MCQ from the commercial laws. Let's start with my brief introduction. In case if you don't know my name, it's Sandeep Khatri. These are my areas of specialization: the constitutional law, criminal law, commercial law, family law, jurisprudence, and law of torts. I have also shared the link of my profile, students, as you can see on the screen. So please make sure you follow that to get all the updates about my special classes and my plus courses. Here is the link of my Telegram channel where you can connect with me and ask your queries related to your judicial preparation. At last, I have mentioned my code, that is Khatri10, which you can use to get 10% of discount as well for all the courses. And also, you can use this code to get all the free to get access of all the free classes available on Unacademy app. So this was about me. Now I request everyone, please be attentive, and this is going to be interactive session. So here comes the MCQ. Just one humble request, students, please, before writing your answer, make sure you write numeric 1, the question number, and then your answer. And this is your first question on your screen. For an acceptance to be valid, it must be. Choose the most appropriate option. Thank you, Ladley, for confirming that. Good evening, Raja. Okay. Thank you, Vakil Sahab. Love from Pakistan. Love from India as well. Okay. For an acceptance to be valid, it must be. Top 3 students to answer correctly. Raja followed by Ladley. Sammy, please do correct your answer. D is not the right answer. B is the correct one. The correct answer is absolute and unqualified. Now, what do we mean by this term? First, you have to make sure that you read Section 7 of the Indian Contract Act properly. So the reason why the answer B is correct, because of section number 7. Now coming to the meaning. Absolute means direct. The acceptance must be direct, and unqualified means there must be no conditions, because the moment if you put conditions on your acceptance, that will make the acceptance, that will turn the acceptance into counter offer. That's why B is the correct one. Next one. Which one of the following has the correct sequence? I think one of the most easiest question you can expect in your exams. Top 3 students to answer correctly. Raja, Ladley, Sammy, and Parminder Kaur. Everyone's answer is correct, and there is, I don't think I need to explain the reasons. It start with offer, acceptance, consideration, then agreement, and finally it with the help of section 10, it is your contract. Now I have one question attached to this concept. Let's see if you can answer that in the comments. And I request everyone and students, whosoever is watching this video, please do participate. Okay, do answer. Okay, don't think about that the answer is going to be the correct or the wrong one. See, that is not our priority here. Okay, you are in this class, so you are here to learn something. Now my question is, students, when it comes to the concept of offer, okay, let's put this situation that way. See, when it comes to contract, the first step is offer, but which one is exactly the first step? It is invitation to offer or the offer, which means which one is essential for the contract? Offer, invitation to offer, or both? Answer in the comments. Which one is the essential for a valid contract? Offer, invitation to offer, C, both, and D option, none of the above. Okay, I have given you all the 4 options as well for this question. Very good evening, Parminder. Okay, Raja, you have answered correctly. That is offer. Yes, this is the correct answer. Invitation to offer may be in some cases. The contract may start from invitation to offer, but the contract is one which is essential. Invitation to offer is never an essential for a valid contract. Next, an offer is revoked. Good evening, Kanika. Top 3 students to answer correctly. First one, Kanika, followed by Raja and Sammy. Everyone's answer is correct. That is D, which means an offer, can be revoked by any of these concepts. Now my question to you is, can you recall the exact section number where all these 3 points has been mentioned? Yes, please. Can you please recall the section number in the comments? Be quick. The section number. Yes, Sammy, correct answer. Raja, Ajay, everyone's answer is correct. That is section number 6 we are talking about. Now the last question in association with this question, when it comes to section 6 that deals with revocation of proposal only, revocation of acceptance only, or C, both acceptance and revocation. When it comes to section number 6 that deals with revocation of proposal only or revocation of acceptance only, or both. Answer in the comments. First one to answer this question, Antpal Kaur Gill, both. Ajay, both. Raja and Kanika, correct answer. Please do correct yourself, whosoever has written both. Ajay, Sammy, Parminder and Anpal, please do correct your answer. Okay, just once you are done with this class, just open your Bayer Act again and read the heading. Okay, section 6 deals with revocation of offer only, period. That's it. It has nothing to do with acceptance. Next, consensus ad idem means one of the most famous maxim from the Indian Contract Act. These are the most, I can say, easiest question you can expect in your exams. And these are the most repeated questions from your previous year questions. Consensus ad idem means. Top 3 students to answer correctly. First one, Kanika, followed by Raja and Ladley. Yes, everyone's answer is correct. That is B, which is meeting of minds upon the same thing in the same sense. Can you recall the section number for this one? Yes, anyone can tell me the section number where this maxim comes into the picture? Wonderful, Ajay. Section number 13. बहुत बढ़िया कनिका. Yes, Parminder, correct. Section number 13. Next. An agreement which is enforceable by law at the option of one party. An agreement which is enforceable by law at the option of one party. Valid contract, voidable contract, illegal contract. Top 3 students to answer correctly. First one, Antpal, followed by Kanika and Parminder. C is the correct answer, that is voidable contract. Now, who can answer when we say voidable contract is at the option of one party? Who is that one party? Please do explain that one party in the comments. Who is that one party we are talking about here? Correct answer, Parminder, 2I, which is not at fault. Party to contract, who completes the obligation of contract. Agree. I hope, Ajay, I'm just hoping that you actually wanted to write aggrieved party. Okay. Okay. The question was not that difficult. I'm getting the answers, but not the one that is, hit the bull's eye. I'm not getting that answer. Okay, let me tell you this as well. By going through with your comments, starting from Kanika till, Raja, I can say that you know the answer. But the problem is you are not able to express it. You are not able to write it. And this is something, a skill which you need, to the best at the time of your mains examination. Now let me explain this. Who is that one party? That one party is that party against whom coercion has taken place. That one party is one party against whom undue influence has been done. That one party is that party against whom misrepresentation has been done. Fraud has been done. So that is one party we are talking about. I hope now it's clear. Done? Chaliye ji. Moving to the next one. A contract is an agreement creating and defining obligations between the parties. This definition was given by. The question is, this definition is given by, not defined by. So name the jurist. Very good evening, Prashant. I saw Prashant and Kanika in my class after a long time. So welcome back. Okay. Starting from Antpal, everyone is writing B. Okay, Raja. Okay, top 3 students to answer this question correctly is Raja, followed by Kanika and Parminder. Students, we all know that yes, Pollock, Mullah and Pollock, there is a book as well of Indian Contract Act, which I think one of the best books ever written on Indian Contract Act. So it's a good textbook. But again, here the correct answer is settlement. Okay, so C is the correct answer. This definition is given by the settlement. Now coming to definition, there is one more definition which has been given by Anson. Okay, I hope each one of you can recall that statement. Please do write that statement in the comments, which is that one famous statement that is given by Anson in relation to acceptance. Kanika, this word gunpowder only is not going to be sufficient enough. It's just a word. I'm asking about the statement. Wow, sir, वो train वाली light वाली बहुत बढ़िया. Now just imagine that if the same question has been asked to you at the time of interview, can you answer these, can you use these kind of terms? Huh? Train is something full of gunpowder. Jalti hui barood. You know, the only thing here, the next comment which I'm expecting here is the famous dialogue of Shatrughan Sinha. राइट जली को आग कहते हैं, इससे अच्छा तो वही यूज कर लो. चलिए, मूविंग टू द नेक्स्ट वन. An offer made to the whole world is called. चलिए, okay, I'm trusting everyone. An offer made to the whole world is called general offer. I think everyone's answer is correct, starting from Anpal till followed by Ledley and Raja. Each one of you, your answer is correct. That is general offer. Now, can anyone tell me what is the major difference between general offer and invitation to offer? How do you figure it out? That it's a case of general offer and this one is invitation to offer. How do you get to know about that? What is the major difference? Yes, anyone in the comments. What is the formula basically I'm asking about? How do you get to know about that? That it's a case of general offer, it's a case of invitation to offer. Yes? Should I answer? इनविटेशन में फर्स्ट ऑफर की वैल्यू सेट होती है आफ्टर बातचीत वेयरएज टर्म्स एंड कंडीशन. ओके, सी स्टूडेंट, let me tell you the formula. The formula is basically when it comes to general offer or invitation to offer, in both the cases, there is one thing that is common, that is advertisement. Now, how you are going to differentiate is when the advertisement is giving you just the information and nothing else. When the advertisement, now listen this carefully, okay? When there is an advertisement in front of you and that particular advertisement is just giving you the information, that is going to be invitation to offer, okay? But when the advertisement is not only giving you the information, that is also telling you to do something, then that is your general offer. So that is the difference, okay? Next. A invited B for his sister marriage and B accepts to attend. This is an example of, interesting question by the way. This is an example of dash agreement. Top 3 students to answer correctly: Parminder, Anumitro and Ledley. Antpal, please do correct your answer. The correct answer is it's an example of social agreement, okay? And now coming to what if B did not show up in the marriage? Will that be a breach of contract? Answer in the comments. If B is not attending the marriage, then is B committing the breach of contract? First one to answer, Anpal, no. Why no? Why no? Everyone is answering no, 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 no breach. Why no? Give me the reason. Give me the reason. If you can tell me the reason, I can assure you, your basics are clear. Social agreements are not enforceable, no legal obligation. Okay. So Kanika, basically you want to try to say that social agreements are not contract. Now coming to my last question, why social agreements are not contract? What is the reason for that? Why social agreements are not contract? Yes, please answer this. Be quick. And yes, I have got the correct answer from Monica. Intention to create legal relationship is not there. Yes, because there is no intention to create legal relationship. If someone, Mr. A is inviting, giving an invitation to B for the marriage, there is no intention to create legal relationship. And if there is no intention to create legal relationship, that will not be taken as a contract. And if there is no contract, there cannot be any case of breach of contract, right? चलिए, परमिंदर मे भी शायद मुझसे मिस हो गया हो, ठीक है? See, I am getting a lot of comments, तो अगर किसी का, in case if I miss someone's comment, just ignore that, okay? I can tell you that is not something which is going to be intentional, okay? So there is no mention here. Next one. If a new contract is substituted in place of an old contract, it is called as, come on. You should not take more than, 2 seconds to answer this question. Because even if you are, thinking about this, there is a problem. And do write the section number as well. Whosoever is answering it correctly. Kanika, answer to your question, yes, intention to create legal relationship is one important ingredient. See, suppose even if when it comes to India, you can refer section 25 here. Okay, so suppose if a father and son is coming into a contract, there must be something which is in written, or you can say registered, right? If it is without consideration. Okay. Okay, everyone's answer is correct. This one, starting from Raja, Monica. Okay. Parminder, you have answered C. D is the correct answer. Novation. Next one. Yes, Balfour versus Balfour is a landmark judgment here of husband and wife. A supplies B, a lunatic, with necessaries suitable to his condition in life. Okay, anyone who is attending this class and saying, sir, this is not the case of quasi contract. Anyone in this class here who is saying ki question number 10 is not from quasi contract? Anyone? I hope everyone will agree on that. Ki sir, this is a simple example. This is basically an example. Okay, let me tell you the exact one. This is illustration first of section 68. Basically, it's a quasi contract, right? Now, my question to each one of you is a very simple one. Quasi contract is a contract. Yes or no? Answer in the comments. I'm repeating myself. I'll be slow enough so that you can understand easily. Quasi contract is a contract. Yes or no? Answer in the comments. Antpal, first one to answer. Yes. Anomitro, no. Yes, no. Kanika, no, they are like contract. No, yes. I think it's a kind of a 50-50. Some students are saying yes, some are saying no. Okay, if you are saying yes, it is a contract, can you give me any reason for that? If you are saying, sorry, yes, quasi contract is a contract, can you give me any reason for that? Okay, Raja, no. Shrishti, no. Ajay, yes. Okay, let me conclude then now. See, students, listen carefully. The correct answer is quasi contract is not a contract. Because if quasi contract is a contract, then we don't need section 68 to 72. Okay, so quasi contract is no contract. Why it is not a contract? Because see, even in this case, if you see, is there any contract between A and B as far as this question is concerned? You just answer me this. Is there any contract between A and B here? A is supplying B a lunatic with necessaries. So is there any contract between them? Answer is no, sir. There is no contract. But there are now the question is, sir, what is between A and B? If there is no contract and still A is entitled to reimburse from B's property, then what kind of relationship is between A and B? Then the answer is going to be there is a certain relationship between A and B which is resembling, the keyword here, which is resembling like a contract, and we call it that quasi contract, and quasi contract is not a contract. I hope everyone is satisfied with that. Chaliye ji, next one. The original contract need not to be performed when there is a dash of a contract. Starting from Anumitro, everyone's answer is D, and that is completely correct. Yes, even in the case of recession, novation, alteration, the original contract need not to be performed by the parties. A tradesman leaves goods at B's house by mistake. B treats the goods as his own. Starting from Anumitro, everyone's answer is C, Raja, Ladley. Okay, that is the correct one. Nothing much to explain. Again, an example from the quasi contract. The consideration must be dash and lawful. Complete the sentence. The consideration must be dash and lawful. Choose the most appropriate option. Top 3 students to answer correctly. Just a second, I need to see question number 13, right? Shrishti, Antpal, and Ladley. Top 3 students to answer correctly. D is the correct answer. See, students, there is usually a myth, in the minds of students that consideration is something which is money only. No. When you read section 2D, the term that has been used is something. And the meaning of that something is something, which has some value in the eyes of law, which means that has some real value. So the correct answer here is real. The consideration must be real and lawful. कनिका, यस लाडली, वास्तविक होना चाहिए. कनिका, लाडली एंड अनपाल, एवरीवन्स आंसर इज करेक्ट. ठीक है. 14 का डी. सी भी किया है किसी ने. राजा, प्लीज डू करेक्ट योर आंसर. Ladley, please do correct your answer. D is the correct one. It's counter offer. Okay. And now who can tell me what is the difference between cross offer and counter offer? How do you actually differentiate between them? What is that one formula? Anyone who can recall the formula? What is the difference between cross offer and counter offer? See, the thing is, I can give you 10 questions on cross offer and counter offer, and I know exactly all the questions you can solve easily. But the moment if I'm asking you something, for the sake of your interview, or if you need to write in your mains examination, that is, something where the problem lies. And I just want to mark that. Okay? And that is going to be the takeaway from this class. Okay? The learning from this class. So you should be able to identify your problem. I'm able to answer the PT questions, but not at the time of mains or interview. So that is why I'm doing this kind of exercises. Sir, same offer from one party and another party at the same time is cross. क्रॉस ऑफर में बोथ साइड से ऑफर होता है. काउंटर ऑफर में हमें पता होता है दूसरे का ऑफर क्या है. सृष्टि, सेम टाइम इज नॉट वन ऑफ द एसेंशियल. इफ सपोज आई एम राइटिंग अ लेटर, even at that time counter offer may take place. So it's, the same time is not something which is an essential. Okay, Monica, in counter offer, reply is expected. Not really. Suppose if you are in a market and you are not, no. आपके आंसर्स पढ़ के ऐसा लग रहा है आप बस अंधेरे में तीर मार रहे हो. Everyone. I'm just wondering what you are going to write in your mains examination, by the way. See, let me give you some hint for this. There is a trick to answer these kind of questions. Whenever you are reading a topic now, so suppose if you are reading, cross offer or a counter offer, just pick some, important keywords. You don't need to remember the complete sentences or the complete paras. All you need to recall is some keywords. And if you can do that, you can easily write good answers at the time of your mains examination. Okay? By reading all your answer, I can tell you that you know the concept. I can assure you this. But this is something कि सर आप भावनाओं को समझ जाओ और हमें मार्क्स दे दो. This is that kind of an attitude. So this will work on me, but not on the person who is going to check your mains answer sheet. Right? Chaliye. Next one. Write down the section number as well, which section you have applied to answer this question. Top 3 students to answer correctly: Antpal, Ladli, and Shivangi. Everyone's answer is correct. That is B. Each one of you, your answer is correct. A singer contracts with B, the manager of the theater, for 2 nights in every week during the next 2 months. This is again one of your illustrations. And B, from the Bayer Act. And B engages to pay, her 100 rupees for each night's performance. On the 6th night, A willfully absents herself from the theater, and B, in consequence, resigns the contract. Now choose the most appropriate option. Kanika, 69 what? Just complete your question. Top 3 students to answer correctly: Anumitro, followed by Ladli and Shrishti. Everyone's answer is correct. That is C. A, for natural love and affection, promises to give his son B rupees 1000. A puts his promise to B into writing and registers it. This is a smart act. This is a smart act from the son. Top 3 students to answer correctly: Anumitro, Arathi, Lakshmi. Correct answer, Monica. Antpal, please do correct your answer. C is not the correct answer. Do read section 25. This is again one of the illustration from section 25. Okay, just because there is writing and registration, so even if there is no consideration, still it will make a valid contract. A agrees to sell to B 100 tons of oil. There is nothing whatever to show what kind of oil was intended. The agreement is starting from Anumitro, Parminder and Kanika. Everyone's answer is B, and that is the correct answer. Section 29, Parminder, absolutely correct. A agrees to buy from B a certain horse. It turns out that the horse was dead at the time of bargain, though neither party was aware of the fact. The agreement is, and do write the section number as well, by using which section you have answered. Starting from Anumitro, Ladli and Arathi Lakshmi, everyone is answering D. Okay, section number 20 as well. Okay. Okay. How did you figure it out? See, listen the question. The question is going to be very, very interesting. How did you figure it out that this is a case of section 20 or section 56? So basically, what is the major difference between section 56 and section number 20? Because 2 students have answered section 56 as well. So yes, Why this is a case of section 20 and why not 56, or why this is a case of 56 and not section 20? You answer, please. Ajay and Anomitro, 56. Rest of the students are section number 20. Okay. Knowledge of facts, sir. No, Parminder. No. 56 is impossible to perform. No, Antpal. No. Kanika, knowledge. Kanika and Parminder, if you are writing knowledge, you have to, explain it further. The term knowledge only is not going to be sufficient enough, for your answer, because knowledge means many things. Many other things also maybe, fall here. So you have to explain further. Bilateral mistake, knowledge. No. Listen carefully, students. There can be two situations. One is of section number 20. One is of section number 56. Section number 20 is basically void agreement. Section number 56 is contract becomes void. So the one major difference falls here only. यहाँ पर contract बना ही नहीं है. There is no contract. But in this case, there was a contract, but because of circumstances, this becomes void. Now coming to the answer. If at the time of making the contract, the horse was dead, before making the contract, if the horse was dead, that is going to be treated as a void agreement. Now let me give you one example. Suppose there are two parties. Just a second. Suppose there are two parties A and B, and A is the one who is selling the horse. Okay? Now the moment they are making the contract was, suppose today is 9th of November. Now on the 9th of November, they are making an agreement that A is going to sell the horse, B is going to pay the price. Now if the horse died on 8th of November and A and B was not aware of this situation will fall under void agreement. I hope everyone is clear with this. Now suppose the second example. If they are making an agreement on 9th of November, okay, that on 15th November they are going to perform. On 15th November, A is going to deliver the possession of the horse to B. But on 10th of November, if the horse died, in that case, there was a contract which now becomes void. There was a contract, but because of the circumstances, the horse died, it becomes void. So now the case will fall under section number 56. So I hope now you can easily differentiate between section number 20 and section number 56. Clear? If yes, quickly give me a thumbs up. I'll come back to the MCQs. Okay. Perfect. Let's move to the next one. So in this case, it turns out that the horse was dead at the time of bargain only. So that is why the answer is void under section 20. There is no role of 56 here. Anomitro, here, see why section 20 is applicable, because there was a mistake from the end of both the parties. You have to go with the reasons as well. Okay? There was a mistake from the end of both the parties. Next, now some questions from the SRA, Specific Relief Act. The words and expressions used in Specific Relief Act but not defined in the Act have meaning as defined in the Act. Starting from Kanika, Parminder, and Ladley. Correct answer. The correct answer is Indian Contract Act. Specific relief can be granted for enforcing only. Shrishti, Kanika, Parminder. Correct answer. Everyone's answer is correct. That is a individual civil right. I think the reasoning is also very, very easy. That Specific Relief Act is a civil law. Okay. So that has nothing to do with penal laws. Okay. It can't be like, if Mr. A killed B, no one can demand that we want specific relief, that we want only one punishment for Mr. A, that is of death only. No, this is not how things work. This is not how Specific Relief Act works. Section 5 of SRA deals with recovery of specific immovable property in the manner provided by. That's completely on you, Anumitro. That's completely on you. You may leave if that is the case. Top 3 students to answer correctly: Arathi, Lakshmi, Srishti, and Prashant. A is the correct answer, students. That is of CPC. Okay. Section 6 of SRA cannot be enforced against. Top 3 students to answer correctly, starting from Kanika, Antpal, and Parminder. Everyone's answer is correct. That is C, government. Section 7 of SRA 1963 deals with movable, immovable, both, none of the above. Starting from Kanika, Parminder, and Arathi Lakshmi, A is the correct answer, everyone. Prashant, B is not the correct answer. Shrishti, please do correct your answer. Then it's movable property. See, section number 5 and 6 deals with immovable property. Section number 7 and 8 deals with, section number 5 and 6 deals with immovable property, and 7 and 8 deals with movable property. The specific performance of contract dash by the court under section 10 of SRA Act 1963. And this is an important question, reason being because of 2018 amendment. After 2000, see, before 2018 amendment, this was not wrong that the second name of SRA was discretion. Because in every section, it was the discretion of the court. At the end of the day, it was the courts which needs to be decided that whether they are going to imply specific performance or not. But once 2000, after 2018 amendment, now the picture has completely changed. Now the term may has been substituted by the term shall, which means now it's mandatory. So starting from Parminder, followed by Kanika, Parminder, after 2018 amendments, it's shall now. Shall be enforced. So B is the correct answer. Okay. So make sure you also updated your Bear Acts. In case if someone is using a Bear Act that is, before 2018, please make sure to buy the new one as well. Okay, because there are many other changes as well. Wonderful. क्या बात है. Parminder, first one to answer correctly, followed by Ajay. And I'm super impressed with the answer of Ajay. Reason being, he has answered specifically why A. That is because of section 12A. Okay. So see, the when it comes to specific performance on part contract, there is one general rule, there is one exception. The general rule is mentioned in section 12A. And B, C, D are the exceptions. So general rule says shall not allowed. Okay. Kanika, the question is sufficient. Court dash specific performance of part contract. So basically they are asking about general rule here only. Okay. You will not see when it comes to exceptions, they will ask you what are going to be the exceptions. So in general, you will not imply exceptions by yourself. That is the rule of PT examination. Okay. Who may obtain specific performance under section 15? Starting from Arathe Lakshmi, Parminder and Ladley, D is the correct answer, students. D is the correct answer, all of the above. Special courts under section 20B, again 2018 amendment, 20B established by Kanika, Parminder and Kanika, Parminder and Srishti. Correct answer. Ladley, please do correct your answer. It's A, state government. And obviously the complete answer is state government with consultation of, the Chief Justice of High Court. But, as per to this, the answer is going to be, as per to the option given in this particular question, the answer is going to be state government. Okay. Section 34 sanctions. What kind of declaration? We all know section 34 is declaratory decree. Now, what kind of declarations can be, given under section 34? Very good evening, Shashi. Top 3 students to answer correctly, Parminder, followed by Kanika and Ladley. D is the correct answer. That is a declaration of legal character or right to property. So legal character mein there are cases like father and son, and right to property mein to it's like, the title, for the title of the property. These are some questions from Sale of Goods Act now. What do you mean by symbolic possession? So what do we mean by the term symbolic possession? Thank you for the compliment, Sashi Poonam. Chaliye, now coming to this, B. Yes, everyone's answer is correct. That is delivery of keys of lock of godown where the goods are. B is the correct answer. The most famous maxim of Sale of Goods Act, caveat emptor. Let the dash beware. You know the exact meaning of caveat emptor? Let the dash beware. What is that dash? Kanika, Ladley, and Parminder, top 3 students to answer correctly. Let the buyer beware. Okay, so as per to the answers given in this question, as per to the options given in this question, beware customer is going to be the most appropriate answer. The goods identified at the time of sale of contract is. The one of the most important term when it comes to Sale of Goods Act is the goods. Now, what kind of goods are there? There are future goods, uncertain goods, specific goods, certain goods. But when it comes to the goods identified at the time of sale of contract is. See, once the good has been when the goods have been identified, the most suitable answer between C and D is going to be specific goods. Now, those are going to be called the specific goods. Okay. Once there are nothing called certain goods. There are terms that has been used called ascertain goods. Okay. And that has not been used here. So the correct answer is going to be specific goods. Okay. Parminder Kaur, correct answer. The right of unpaid seller is. Starting from Kanika, Ladley, and Rupinder Kaur, everyone's answer is correct. That is C. Right to lien. So C is the correct answer. Last question. Who is called buyer? This term has also been defined in Sale of Goods Act. Who is called the buyer? एक second. Who was? Kanika, Ladley and Prashant. Everyone's answer is correct. That is 2-1 में defined है. A person who buys or agrees to buy, both are going to be qualified as a buyer. So that was your test, students. Now, anything you are not clear with, you may ask. So students, one important information before concluding this class. I hope you all have already enrolled yourself in the All India Judiciary Scholarship Test, as you can win 100% scholarship on your Unacademy subscription. The test is on November 13th at 11 a.m. This is completely free. If you have not enrolled yourself, make sure the moment you are, this class ends, that should be your first thing to do today. And you can win exciting prizes as well, as you can see here. For the rank 1, there is a tablet. For rank 2, there is a 5G smartphone. For rank 3 to 7, there are earbuds. For rank 8 to 17, there is a home speaker. And for rank 18 to 100, there are gift vouchers. Thank you. You all are welcome. And thank you for the kind comments. That really means a lot. On that note, that's it from my end. See you in my next class. Till then, yes, it's time to say peace.